Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss a case law on interpretation class. Friends, yesterday we have just discussed the literal or grammatical interpretation. Today we are going to discuss very important case law on mischief rule of construction. Mischief, it can be interpreted, it can be construed also. Firstly, it's interpreted, ultimately the construction has come. How this has come? This is envisaged in the very famous Heydon's case. So please remember, what is the mischief rule? So before dealing with the case of Heydon, or let us discuss the point. What is the mischief? Mischief means definitely some defect or some error. This will be corrected by the court by construction. So first of all, they will interpret the issue, ultimately they will construct the matter. This is the importance of mischief rule of construction. Before going to the case, actually the mischief rule highlights 4 points. Number 1, what was the common law before making the particular issue, before making the act? So in the torts class I explained you, entire law, present law came from the common law principles. So what was the common law principle before making the act? And what was the mischief or what was the defect which the court has encountered? And actually what remedy the parliament proposed to invoke or to cure the so-called defect. And now, basing on all these things, true reasonness of the so-called remedy, then the court will give the remedy. First of all, they will observe, so before making the act, what was the common law principle? Now, what is the mistake or mischief? Then how to correct it? Whether the government has tried to correct the same or not, if not, let us correct the same. So these points have been discussed in the mischief case. Now we are coming to the Heydon's case. So actually, this is a case of construction of leases, life estates and statutes. There is a college by name Ottery College, which used to run the religious institutions as well as so the religious denomination, they used to run the colleges. Still we are doing just ABM college and in Mongol and things like that. Saint Teresa. And this Ottery College, they gave, please remember, tenancy to Mr. Ware. So Mr. Ware was appointed as the caretaker of the particular college. He was given the tenancy, so he can reside in the particular bungalow or particular area for whichever time he likes. So that was the agreement. But things are not like that. The things changed. The Ottery College was falling down. So therefore, they have entrusted to a contractor by name our Heydon. So Heydon has taken the contract for about 8 years or so. So he wanted to appoint his own people. He asked Mr. Ware to vacate. But he said, already I was given the tenancy. So there was a dispute arose between Ware and Heydon. While things stood like that, the UK government, they thought that the religious institutions, religious denominations, they are not able to run the show properly. Therefore, basing on the Henry VIII clause or the Act, that is Suppression of Religious Houses Act 1535. So the entire property went to the government. Now, Heydon filed a case that he is the contractual owner. That too, the act has come only after 1 year of his contract, and in the suppression of the so-called Religious Homes Act, please remember, grant to waive is protected after 1 year. After 1 year. Now the point is whether Heydon can continue as a contractor. Number 2, whether Mr. Ware has to vacate. So now the mischief is, the act did not mention that people who are in possession, they will continue or they have also to vacate. Here they have been there for the last so many years. So therefore, the defect is the law is not clear about the people who have been in the particular area. Number 2, whether the contractors can enjoy or whether they have to vacate. That is another problem. Now, these mistakes have been rectified by the court, stating that number 1, Henry VIII clause, it has to be accepted. The law is made in the interest that the religious denominations are not able to maintain, they are not able to run the show. Therefore, the government is the better option to run the show. So the properties should go to the government. So Heydon cannot hold the property. As regards Mr. Ware, the court said that you should show some alternate accommodation to him. Having believed them totally, he has occupied this particular area. Now you cannot evict him abruptly. So give him some alternate accommodation. Then only you make him evict. So in both ways, the mischief was cured by the court. So this is the beauty of mischief rule. I will tell you some other cases in the next video. For the present, I am staying back. Thank you very much.